location off the campus. Also, please remember to unmute your mics if you wish to speak, and then mute your mic again if you wish to speak to avoid background noise intruding on our Zoom call. Chairman Westerfield, are you on?
Yes, sir, I am.
Good. Madam Secretary, call the roll.
Senator Adams. Senator Higdon. Senator Hornback. Senator Howell.
Here remotely in my district.
Thank you. Senator McDaniel. Senator Neal. Senator Nemes.
Present in the room.
Senator Thayer. Senator Thomas. Representative Banta.
Present in the room.
Representative Bratcher.
Present in the room.
Representative Birch. Representative Flannery.
Present in the district.
Thank you. Representative Gentry. Representative Huff. Representative Cook. Representative Massey. Representative McCoy.
Here.
Representative Meeks. Representative Meredith.
Present in the room.
Representative Miller.
Present in the room.
Representative Moser. Representative Palumbo.
Here in my annex office.
Thank you. Representative Pratt.
Here in the room.
Representative Santoro.
Present in my district.
Thank you. Representative Timoney.
Present remotely in my district.
Okay, thank you. Representative Westrom. Representative Koenig.
Present in the room.
Chairman Schickel.
Present.
Senator Neal is present in the district.
Thank you. It's noted.
Thank you.
We do have a quorum and are duly constituted to conduct official business. Welcome, everyone. The first thing I would like to do, I know it's been several months since Senator Tom Buford's passing, but I can't help but think the last meeting that I chaired, he was not only participated in, but he participated in with questions and was very engaged, and now he's no longer with them. So I'd like to observe a moment of silence on his behalf. Thank you. I'll entertain a motion to approve the minutes.
So moved.
For the record, it will be for June 17th and July 26th, 2021. I heard a motion. Is there a second? There's been a motion made and seconded. All those in favor use voting sign of aye.
Aye.
Anyone opposed, like sign. Let the record reflect the minutes for June 17th and July 26th have been approved. Chairman Koenig, do you have anything?
No, sir.
Very well. We have a rather lengthy agenda with some important items on it. The first item on the agenda is fair chance licensing. We have Senator Whitney Westerfield with us remotely. Senator, welcome to this committee. It's good to see you. If you would introduce your guests and proceed with your testimony.
Chairman, thank you both so much for allowing me time. Chairman Schickel in particular, I appreciate you giving up your precious committee time. I know how hard it is to make room for everything, so thank you. We're going to make use of that time as best we can. I've got Martin Harris and Joshua Gaines, both with CSG, attending the meeting. They're going to speak in just a moment about some of the options, but I want to lay the groundwork briefly, if I could, and remind the members and educate the members who have come on to your committee and to the legislature in the last couple of years that weren't there for the 2017 enactment of Senate Bill 120 about what we've already done in this direction. at the heart of what we're trying to do is to make sure that people have an opportunity to be gainfully employed. You've heard me, Chairman, say a number of times that the biggest determining factor, more than anything else, when it comes to recidivism, and you and I on the Judiciary Committee and this our General Assembly talks a lot about criminal justice policy, but the single biggest determining factor about recidivism is whether or not someone is gainfully employed when they get out of custody. If they've got a job and they're gainfully employed and paid, and they're providing for themselves and their families, they're contributing to their community, they're paying taxes, they are substantially less likely to ever encounter the justice system again and further draw down on those taxes and be a burden on the public. So we want to make sure we help people that are in a position to be employed have the best shot at employment. And in 2017, we passed Senate Bill 120, which did a number of things in this regard, involving licensures and certifications and certificates that are provided by various boards and commissions here in the state. Senate Bill 120 did a number of things. And members, if you have the 1 or 2 page document summary of this, you've got these bullet points right here in front of you. And I know they're on the website, I believe, as well. Senate Bill 120 prohibited a direct or required a direct relationship between the prior bad act and the license or certification being sought. So if you were going to be getting a license as a barber or a hairstylist or whatever, and I don't know what the proper terminology is, but whatever that license is, if your prior offense didn't have anything to do with that, then you couldn't be automatically denied that license as a result of that prior conduct. It required an individualized assessment based on the factors of that specific case. It eliminated the broad authorization to use the vague term absence of good moral character, which it sounds good, and it could mean 100 different things depending on the board, depending on the makeup of the board from one season to the next, not to mention from person to person. And importantly, it requires a notification of intent to deny. It requires that board to explain to the applicant, here's why we denied or why we're going to deny your license based on these factors. Too often, people coming out of custody were just denied because of whatever, and they weren't clear on why exactly they could get the license or certification they were hoping to get. Requires that written explanation of the denial and provides, in limited circumstances, an opportunity to appeal that denial. The board still has the final say, as they should. We've given the authority to these boards to make those certification decisions. But I think it's important due process protection to allow applicants to have an opportunity to be heard. If they're ultimately denied, then they're denied. But they ought to have a chance to argue their point, especially if they've demonstrated that they've turned a corner, as we want them all to do. If they've been awarded an expungement because they're entitled to it under statute, or because they've been given extraordinary relief by the executive branch, they ought to be able to explain that. So that's what we've done. And Joshua and Martin are here. Martin, I think, is going to do most of the talking to talk about what we have as options moving forward to expand on this.
Thank you, Senator. Appreciate that explanation. We have 15 minutes allocated for this testimony. If your guests from CSG would introduce themselves for the record and proceed with your testimony.
Thank you, Senator Westerfield, for that introduction and talking about Senate Bill 120. I want to thank the chairman on the committee today, and I also want to thank the members who were present on this committee. So my name is Martin Harris. I'm a legal fellow at the Council of State Government's Justice Center, and I'm here with my colleague, Josh Gaines, who's a project manager on our economic mobility team here at CSG Justice Center. And I just want to give some brief background information on the Council of State Government's Justice Center and some of the work that we do. So we are essentially a national nonprofit organization. We're nonpartisan, and we work with all 3 branches of government, and we provide technical assistance to states and lawmakers and stakeholders throughout the country, and we provide research-driven strategies to offer policy expertise and help to increase public safety and strengthen communities. The economic mobility team, along with my colleague, we're focused on fair chance licensing, and we are doing a landscape analysis of all 50 states. And the key areas that we're looking at in terms of fair chance licensing include assisting states in economic recovery, enhancing good paying jobs, improving re-entry and public safety, and providing businesses with qualified candidate pools. I also want to take some time to acknowledge the role that Kentucky played in the licensing consortium that happened a few years ago. I know that some of the members of the committee participated in the consortium. And just to give a brief overview of what that particular event occurred, members, a number of states participated in this consortium just to talk about the barriers facing occupational licensing. This was an opportunity for open dialogue so that states can have some insight as to what the problem areas were with occupational licensing, what some of the states were doing to attack those issues. And it was really just a chance for next steps. And since that consortium, Kentucky has done a number of things to improve fair chance licensing and enforce some of the provisions that Senator Westerfield talked about earlier. So to talk about the importance of licensed professions in the state of Kentucky, the Kentucky workforce now up to 19.4% of the state's workforce requires an occupational license. This just shows over time, over the past few decades, many jobs now require an occupational license. So just making sure that we open that talent pool up to include those who have been formerly incarcerated so that they have opportunities to be gainfully employed and to provide for their families. Some of the national themes that we've identified based on some of the research that we've done in other states focus on a number of areas. Some of the themes include maximizing opportunity, maintaining public safety, treating applicants as individuals, increasing transparency, and reducing burdens on applicants. And I just want to, as I transition into my next discussion, focus on that last point that I made in terms of reducing burdens on applicants. Senator Westerfield talked about some of the best practices that were implemented in Senate Bill 120. And based on the landscape analysis that we've done and best practices that have been adopted in other states, a key component of the best practices that we've identified is pre-application eligibility determination, which is currently not in Kentucky law, that can definitely add to the current bill that's on the books as a procedural remedy in a sense. And I'll get into what pre-application determination means. Some of the other best practices that are not included in Kentucky include a prohibition on consideration of non-conviction dispositions. These are essentially expunged records, sealed records, arrests that did not lead to a conviction. Also a limitation on consideration of older convictions that have happened years ago in some instances, and also a limitation on the consideration of nonviolent misdemeanors. But to highlight pre-application eligibility determination, we have found this to be a very effective best practice. It allows workers to obtain a decision about whether their conviction will be disqualifying at any time during the application process, including before meeting the general requirements for licensure or beginning relevant education. And Senator Westerfield talked about barbering and cosmetology. I actually took the time to explore Kentucky's occupational license for cosmetology. Just to give an example and some context as to how pre-application can come in and lessen the burden on applicants, a cosmetology license in the state of Kentucky requires 1,500 hours of training within 5 years of enrolling in school. The average tuition associated with cosmetology is around $12,500. So when you consider the time, the training, and the expense of tuition, and also the expenses that are tied to that, whether it's books, whether it's anything associated with that tuition, and you consider the conviction that they've had in their past. For example, if someone has a forgery conviction, pre-application determination would let that applicant know before they even go through with the schooling, with the training, whether or not they're eligible for that particular license. So it really lessens the burden on the applicants. It lets them know well in advance so that they don't have to incur that cost associated with the tuition.
Mr. Harris?
Yes.
I just want, with time management, we're well past our halfway mark, and so I just want to encourage you to because I think you have one more person also that needs to testify, and I'm sure there'll be some questions also.
Absolutely. Thank you, Chairman. So just to wrap it up, pre-application eligibility determination has been implemented in about half of the states so far. And in Tennessee, North Carolina, Arkansas, that have similar decentralized licensing agencies, they have implemented the pre-application determination, which allows for applicants to receive that advance notice before having to pay for the tuition and undergo the training that's associated with that license. So just moving forward with Kentucky already has a great bill that's in place. They already have a number of best practices, and we've identified pre-application as being one of those things to consider moving forward. And I'm here for any questions that you may have, but I want to give my colleague Joshua Gaines an opportunity to speak to you all today to fill in any gaps that I may have had. So thank you, Chairman, and thank you, members of this committee.
Yeah, thank you, Martin, for your informative testimony. Mr. Gaines, introduce yourself for the record, and please proceed with your testimony. Please do not repeat anything that's already been testified to.
Certainly, yes. Joshua Gaines with the Council of State Governments. I'm a project manager on our economic mobility team. I really just joined in to see if I could help out if there were any questions. I was staffed the DOL Occupational Licensing Consortium, worked with Kentucky and some other states as a part of that. So wanted to be on hand, and I think Martin has summed up the issues pretty well. So thank you very much.
I think him and the chairman have done a great job explaining the legislation. I served on the consortium for the Council of State Governments and attended most of those meetings, and this is a discussion that's been going on for quite a few years now. I appreciate you being here, Josh, to answer any questions. We do have some. The first one is Chairman Koenig.
Thank you, Mr. Chairman. And I, too, was a member of that consortium, and a lot of good things came out of it, and appreciate CSG and others working on that. And I heard about the pre-application determination. Senator Westerfeld, is that like the primary ask of this, or are you going to have a more comprehensive bill?
Before he answers, he did state to me when we talked about this, they do not have a bill drafted yet. Chairman Westerfield, do you have an answer for that?
I don't want to repeat what's already been testified to and spoken.
You're a good man.
In that, with regards to the pre-application determination, that makes a lot of sense. My concern is that we have, in the last several years, allowed many of these boards to increase their fees by way of regulation. Because they are running low on funds, and this would be an additional burden upon those boards. And it's a burden that makes sense. It doesn't make any sense to spend 1,500 hours and tens of thousands of dollars to get a cosmetology license to only not be allowed to practice. That said, I don't know if there would be a cost to the applicant to get that determination, but that might be something to consider to help alleviate the additional burden on these boards.
Chairman, I would look at the other states. Utah, Tennessee have that pre-application step already in place. I'd look to see if any of those states charge their applicants. I don't see a problem with some sort of reasonable fee for the applicant to defray some of that cost. That seems to make sense to me.
Thank you, Mr. Chairman.
You're welcome.
And this is Josh.
Yeah, Josh, go ahead.
Yeah, I just wanted to note that that is a common feature in many states, particularly where they can expect some additional costs to be incurred. So a nominal fee, if only to either cover the cost of reviewing the application ahead of time, or to just ensure that a person has some sort of ante on the table. That really
like that.
makes it worthwhile, right, for the licensing board to do that. You have to prove that you really are serious about this and ready to move forward. So we see statutes saying, either, the board may charge a reasonable fee to recoup its costs. Sometimes there's a dollar value in statute, shall not exceed, $50 or whatever it may be.
My quick review of the summary that CSG provided, I think, has every one of our surrounding states has that in place.
Thank you.
The pre-application.
Thank you. We do not have any other questions, so thank you all for being here. Thank you for the presentation, and I look forward to continuing this discussion during the session.
Thank you, sir.
You're welcome.
Thank you, members.
The next item on the agenda is sort of related. It's military spouse licensure portability, something that we also talked about during the consortium. Anyone that is here for that item, if you would come forward to the table. Don't be bashful. You don't have to agree. We have everybody here together usually. Do we have anybody remotely that's here for this military spouse licensure portability?
Yes, Norma Kirk McCormick, remote from my district. I'll be carrying the bill.
Well, welcome. And identify yourself again.
Representative Norma Kirk McCormick from District 93.
Welcome. Is there legislation drafted?
It's in the process. It's been sent over for drafting.
Okay, good. And I see my good friend Representative Hart here. Welcome to you. It's good to see you again. Introduce yourselves for the record and proceed with your testimony. We have 15 minutes allotted.
I'll kick off. Representative Johnson, 13th District. I'll be a bill sponsor for one of the bills that we'll be discussing today.
Representative Mark Hart, 78th House District. I'm be the sponsor of the EMS portion of this legislation we're going to discuss.
Eric Sherman, Department of Defense State Liaison Office. I'm here to testify today.
Welcome, gentlemen and lady. Proceed.
Well, good morning, Chairman Schickel, Chair Koenig, committee members, honored guests. Thank you for inviting the Department of Defense to discuss how the emergency medical services, occupational therapy, and licensed professional compacts, interstate compacts, facilitate military spouse professional license portability. My office works with the professions to help them obtain state-approved for compacts portability. We work with them to create reciprocity for military spouses and improve interstate practice within their respective professions. For example, these compacts aid practitioners for supporting mobility, in which turn can increase public access to services while preserving the regulatory authority of states to protect public health and safety. As I said, my name is Eric Sherman. I am the Southeast Regional Liaison for the Defense State Liaison Office, or as we call it, the DSLO. We operate under the direction of the Undersecretary of Defense for Military Personnel and Readiness, and we operate within the Office of the Deputy Assistant Secretary of Defense for Military Community and Family Policy. I've had the pleasure of meeting many of the committee members previously and working with some of you as well. So it's always good to be back in Kentucky with folks who have such a sincere interest in helping our military spouses, and we thank you. Actually, the DSLO was established in 2004 to improve communications between the DoD and state policymakers for addressing personnel and readiness issues that intersect with state-level policy. Our mission is to research potential issues and bring these to the attention of state policymakers to help them understand and resolve them. We also team up with government agencies and stakeholders like the Kentucky Commission on Military Affairs and the Council of State Governments who helped cultivate the information and develop communications in their states. And I'd like to thank General Bullard and Mr. Masters for participating with us today, if they're able to make it. So we focus on top 10 key issues identified through our offices, through the Secretary of Defense and military service offices, through the Guard Bureau. And these key issues represent areas where states can play a crucial role in improving the quality of life for our military families and significantly improve operational readiness. I became a regional liaison shortly after retiring from the Navy. I married my wife, Catherine, at the beginning of my 20-year military career, and soon after had a son and daughter to complete our military family. So like so many other military families, we experienced the difficulties being talked about today. In short, Catherine changed careers 3 times during our military career until she settled in on the education field as a school counselor. I finally decided to complete a tour of duty as a geographical bachelor to give my wife a chance to build her career, and then decided to retire from service to support my family. Frequent moves combined with cumbersome licensing and certification requirements limit career options for military spouses. Many give up careers altogether or live separately from their service member spouses. So removing these barriers, creating reciprocity and licensing requirements, and facilitating placement opportunities can improve a military family's financial stability, speed the assimilation of the family into a new location, create a desirable new employee pool for the state, and maintain a family's well-being. Spouse employment continues to remain one of the DoD's top military family issues, with over a third of the working military spouses requiring a state license. Now, the DSLO originally focused on improving licensure portability using state-specific laws to reduce the burdens associated with the occupational relicensing of military spouses as they transferred into a new state. At that time, Kentucky worked with our office and developed policy for spouses and service members. The General Assembly continued working to improve policy with the passage of House Bill 323 in 2019. The bill added spouses to KRS 12.245, which required boards to provide a temporary or permanent license within 30 days based on required minimal documentation to complete an application. In review, the policy places the burden of proof on the board to demonstrate cause for rejection, minimize paperwork to complete an application, and establish a formal appeal process. So the reason I reviewed that is because this became a best practice policy for spouse licensure portability. My colleagues and I, regional liaisons throughout the country, are currently delivering this policy to states around the country to help them resolve their own policy concerns. Your policy, Kentucky Revised Statute 12.245, is impacting the lives of over 100,000 military families stationed around the country. And DoD is proud to have partnered with your legislative body and the KCMA to develop this policy. So as we continue to study licensure portability, we learned that the best possible licensure opportunity for military spouses comes through states committing to 2 lines of effort. One line of effort impacts current military spouse licensure transfers, and the other creates long-term follow-on opportunities for reciprocity. Together, they provide near-term accommodations for military spouses and long-term opportunity for reciprocity. Policy changes in each state's licensing laws provide near-term relief for military spouses, but still require them to relicense. These policy changes also require licensing boards to maintain special processes for military spouses and additional communication resources to help make these processes readily available to military spouses. We see this condition in laws like KRS 12.245 and universal licensure. Occupational licensure compacts provide full reciprocity, but take multiple state action to become effective. However, when states commit to approving compacts, they provide true licensure reciprocity, as each compact allows the spouse to practice their profession in different states without reapplying for a license. So here's how the 2 approaches work together for military spouses. Until multiple compacts are approved by multiple states, the individual state laws provide a more streamlined license opportunity. Once compacts are established in multiple states, military spouses have the benefit of full reciprocity. Additionally, state licensing boards have the opportunity to begin streamlining their processes since compacts impact all practitioners, and boards can start reducing the need to have special processes for licensing military spouses. Both initiatives are important. Occupational licensing laws can reduce the number of unqualified individuals offering their services in that profession and increase overall public safety and welfare. However, because licensing laws are established independently by each state government.
Eric?
Yes, sir.
For time management, you're going to need to wrap it up because your colleagues aren't going to have any time.
Go ahead. Okay. And I've got about 2 more minutes, sir. Their criteria for evaluating competency differs by state. The interstate compacts offer an opportunity for standardization and transfer into the state, but they work hand in hand with the current state licenses. So I am saying that we need both of these. Representative Johnson has offered to sponsor the Occupational Therapist Compact. Representative Kirk McCormick has offered to sponsor the Licensed Professional Compact. These compacts allow the military spouses to designate a home state for their license and use the privilege to practice provision to work in member state without obtaining another license. Representative Hart is sponsoring the EMS Compact, which simplifies the endorsement requirements for transferring a license. These compacts will not only help the military spouses, but help attract healthcare veterans transitioning out of the service. Compacts are the most durable way to enhance services and provide flexibility long-term while respecting individual state practices and regulations. And Kentucky is recognized as one of the most aggressive participants in the interstate compacts. So on behalf of the military families, we ask for your continued support. And I'm happy to answer any questions.
Mr. Chairman, just to put your mind at ease, we've allowed him to make the entire presentation, and we are mainly here to answer questions. And to, I will answer the one that you asked if there was legislation already drafted. The bills are being drafted as we speak. As soon as we get the drafts, we will have them emailed out to all the committee members.
Thank you, Representative Hart. That does help my heartburn. Thank you.
Okay.
Yeah. Representative Johnson.
I'm just here as to answer any questions you might have. I will provide a little perspective, if I could, very quickly. My wife and I were both graduates from Western Kentucky University back in the 70s. I was commissioned in the Army. She chose to follow my career, even though she graduated with 2 technical degrees compared to my 1 communications degree. She had a great future if she'd wanted to follow that career. Instead, she chose to support my military career. I won't go into a lot of details, but when we would move from one location to another, she would start all over again, trying to establish herself. And then back in those times, that was just the way it was. But now the DOD and our state military representatives are working to make it available for spouses to further their careers at the same time the military members further their careers. It's a great opportunity, and if we don't do it, we're just missing out on a lot of professional services, a lot of expertise in our state that we could have if we would do this. So I'm going to highly encourage that we do these compacts, not only for the benefit of the military spouses, but for the benefit of this state and our professional resource pool.
Thank you for
Thank you, sir.
Yeah, thank you for that personal testimony. We heard a lot of that testimony during the consortium meetings also. It's always good to hear from someone who's experienced it personally. We do have several questions. We have about 2 minutes left for this topic. Senator Higdon.
Thank you, Mr. Chairman. I'll be brief, but this was heard, I think, last month in VMAPS, and the appropriate place for it is here, where Senator Schickel and Chairman Koenig have do a great job of vetting these compacts, and we want to make sure we get them right. So this is the right committee, and I know the association is in favor of this legislation and want to be supportive of it. And so, Eric, thank you for being here today. I do have one question. Before these compacts are really valuable, there has to be other states involved in the compacts. Can you tell us how many other states are already signed on to this compact and maybe who they are?
Yes, sir. That would take a little bit. May I ask if I can, Mr. Chairman, can I send you basically a total
That would
listing?
be great if you would submit it to committee. We'll make sure all members get it, if that's all right with Senator Higdon.
That'd be fine. Thank you, Mr. Chairman.
You're very welcome. I also wanted to recognize Representative Kurt McCormick, who's on with us remotely. Did you have anything you wanted to add, Representative?
No, but I have a daughter-in-law that is a doctor in mental health, and she's licensed in the tri-state area, Kentucky, Ohio, and West Virginia. And she works with a lot of the veterans and military folks. And she complains all the time, hoping that we can do something to make this easier for licensing and regulation. So I'll be doing as much as I can to get this compact through. And I appreciate your all's assistance and cooperation.
You're welcome. Representative Banta?
Yes, quickly. If I am in the EMS, I love this bill, by the way, but if I'm in the EMS and I move to Kentucky, would it be permissible to give them a short tutorial on something that might be different in Kentucky than, say, it was in California when they moved here?
Go ahead. Representative Banta, so the nice thing about the interstate compacts is it's just a means to get a license into the state. It doesn't take away the state's authority in terms of demanding the privilege or the practice standards. So whenever a member could even be licensed in another state and just using the compact to practice here, they're still responsible for maintaining the standards of practice within the state.
And I would add, when they come to the whichever respective state, they've got to follow the scope of practice for the paramedic or the EMT in that scope of state. So it doesn't really change how we operate in the state. It just allows them to have an easier path to be able to practice in the state.
Perfect. Thank you.
Oh, time's up. That's Grandma's oven timer there. I keep up there. The cake is done. Now, this is a great discussion, and I would encourage you to get this down on paper because one thing, and this goes around some of the questions, Representative Banta's excellent question. On these compacts, I always run them by different folks that are very interested in our state standards and our state sovereignty to make sure that we're not, and we've had quite a few that compacts over the recent years who have had hiccups. And normally it takes time. So I would encourage you to get these pre-filed so we can look at them so that when we get into the session and then I can start running by the people they need to be run by. Because I would encourage you to do that.
And
thank you.
We totally plan on doing that. And I will put this out to the committee. Feel free to email or contact any of us. And like with the EMS that Representative Banta mentioned, we're currently working with K-Beams, Kentucky Board of Emergency Medical Services, to address. They've got several issues. We're trying to address them as we speak. So when you're going to see a pre-filed bill, but like all pre-filed bills, there'll be changes probably as we work through that with K-Beams by January. But we are aware of some issues. We've already been in communication with K-Beams about some issues, and we are trying to address every one of their issues and concerns before January. And we will share that with the committee as it progresses.
Yeah, that would be helpful because Senator David Givens in our leadership has a special interest in these compacts. I always run them by him. Okay. Well, thank you all. Any other questions? Great discussion. Thank you.
Thank you, guys.
Thank you.
I see Representative Richard White is here, so we're going to take him next because I know your time's valuable. Come on up. And plus, I like your bill. It's a server age limits for alcohol. This is actually something that I carried last year, and we didn't get it through because there was just too many other things going on. But I know with COVID, going on. There's a lot of small businesses, and I can speak for my district. I've had several small businesses in my district contact me about this legislation, so I'm happy that you're going to do this, Representative White. I believe the committee has heard about this before, if it's what I'm thinking, but introduce yourself and proceed.
Thank you, Mr. Chairman. I'm Representative Richard White from the 99th District, and
where is that?
That's in Lewis, Round, and Elliott County, Kentucky, in the eastern part.
Okay, got it.
It's God's country.
I think so.
But anyway, I'm sure everybody here is aware of, with this COVID, the situation of the labor shortage in all the service industries, the grocery stores, drugstores, restaurants, bars, whatever. And I think if we could lower the age to serve alcohol to 18 years old, that would give an opportunity for a lot more employees to work, in the restaurant business and drugstores and grocery stores. But I have a assistant here, a friend that's in the restaurant business for several years, owns several restaurants.
Well, let's hear what he has to say.
Yes.
Thank you. My name's Terry Fitzer. I'm a restaurant owner-operator. I have multiple units. We've experienced, of course, post-pandemic, difficulty in employing people. And I'm just here to really answer questions and ask for some help with it, because it would be a tremendous asset if we could open up additional avenues for employees. And at this point, it's 20 in a day, I believe. 18 would open up numbers. I couldn't tell you what they are, but from experience, I have a restaurant in Virginia, and in Virginia, 18-year-olds are allowed to serve.
Oh, okay.
We've been in continuous operation there in 20 years. Have never experienced any problems, but it is much easier to obtain.
And the way I understand this bill, it's not quite just lowering the age of service to 18. The way I understand it, this is specifically what it does, because I think for me this makes more sense. What it does is it lets waiters or waitresses who serve tables at 18, your bill doesn't allow someone to tend bar at 18, does it?
It does not.
That's what I thought. And to me, that's a big difference. So we're talking about someone who's 18, who's eligible for the draft, can go into service, is legally adult, under the supervision of someone who's 21, serving tables. And I think that's a big difference versus somebody that's tending bar all by themselves at 1:30 in the morning and is only 18 years old. To me, that's a bit, not that I've ever been in any bars, but that seems to make more sense to me. Am I correct?
Yes, sir.
Questions or comments? Senator Higdon.
Thank you, Mr. Chairman. Looking at this, I'm trying to figure out, you strike some language, and especially the one that talks about non-quota retail license, grocery stores, etc., would fall under that category. If I'm reading this right, that if I owned a grocery store, I wouldn't be able to employ anybody under the age of 18? Is that what it's saying?
Now, repeat, please.
Okay, if I owned a grocery store and I had I sold beer, and would you strike that language in this bill?
Well, the way it is right now, if you're in a grocery store, drugstore, whatever, and you're 18, 19 years old, and you're a checkout person, somebody walks up to you with a six-pack of beer, they would have to get somebody that's over 21 to come in, or over at 20 to come over to finish the checkout process. And this would allow the 18, 19-year-old go ahead and check them out.
But if I'm reading it right, if I wanted to hire a 16-year-old as a cashier, I couldn't do it?
Correct.
No,
okay.
Well, still good.
That's not the intent.
Yeah.
That's not the intent, but that's the way I read it, Mr. Chairman.
You're exactly right. That's what we have. Thank you.
Yeah, that would need to be corrected.
It's exactly why we have these meetings. Yeah. Unintended consequences. And hopefully, so you heard what he said, and I know that's not your intent, so we need to fix that.
Yes.
Anything else? Well, I look forward to seeing it over in the Senate, and I think there's a lot of people really supportive of your legislation. Thank you for doing it.
Thank you, Mr. Chairman and the committee.
Thank you.
House Bill 340, an act relating to radon safety. Committee member Kevin Bratcher is the bill sponsor, and you can either stay up here or go to the table. And I see we have my good friend Brandy Cantor here and Chris Nolan. Boy, wasn't extinguished. Bring out the.
And we'll be brief.
Well, I hope so.
Apologies that Kyle Hoyleman could not make it this morning. He had a workplace emergency that he had to attend to. So,
well, I think that you all upgraded. You're here. So.
Thank you.
You know, Mr. Chairman, ever since I've got involved with this a year ago, I found that radon is one of the top leading reasons for lung cancer in America. 22,000 a year cases of lung cancer can be traced to radon. So I think this is a good bill. It raises the awareness. All this really does, though, is repeals the Radon Program Advisory Committee and creates a Kentucky Board of Radon Safety. This will mirror the traditional board appointment process of the other boards. There are 7 board seats, 4 of which are radon professionals, and 1 will be a public health professional. The realtors and the home builders, which is important to me, will hold non-voting seats on the board, and it's my understanding that they are in support of this bill. So,
what a great job explaining the bill. And Ms. Cantor, correct me if I'm wrong, but isn't this the bill that got all the way over here, and at the last minute we couldn't get done because I was so cantankerous?
Yeah. Not for that reason, but for due diligence, we wanted to make sure that it didn't get rushed through, so we held it over till this session.
Are there any questions? Thank you.
All right. Thank you.
I'm sorry, there is a question. Senator Higdon.
That's okay, Mr. Chairman, but since you called on me, when we create this board, is it self-sustaining? Will it generate enough license dues and without depending a whole lot on fines to be self-sustaining?
Yes, Chris Nolan on behalf of the Kentucky Association of Radon Professionals. Yes, the amount of licensees and the license fees that are paid for certification will generate enough funds to make the program self-sufficient. There's also federal EPA dollars and other federal dollars that we can tap, and the state of Kentucky currently is bringing in several $100,000 that can be used for the program as well.
I want to agree with Representative Bratcher that radon is a silent killer, and there's a section of Kentucky that radon levels are very high, and we need to educate the public on that and work on that. But one other issue in the bill that I want to make sure that we vet properly is subpoena power. Mm-hmm. And we need to be very particular about who we grant subpoena power to. How important is that to your bill?
What we did is mirrored this. We're moving this program from the Department of Public Health right now is where it sits, and we're moving it over to professional licensing in the Public Protection Cabinet. And this mirrors the language that's in about 20 other boards that are over there. They all have some varying language around subpoena power and being able to do investigations. So that language is included in all those as well, from physicians, emergency medical services, all the way to geologists. All of those boards have similar language.
Okay. Thank you, Mr. Chairman.
You're welcome, and thank you all. Is there anyone else anyone else? Thank you all for being here.
Thank you.
That leads me to a comment, the question that Senator Higdon asked. You know, Senator Buford used to ask some great questions. I mean, he really did. He dug in, and he always did it in a humorous way, but he had some great questions. And I would like to encourage the members of the committee to ask these hard questions, because I like to ask these hard questions now, not during the session, not when we're in committee during the session, so we can evaluate the legislation that's before us better. what we do here is very important because we're talking about changing the laws of the Commonwealth of Kentucky. So that's why it's so important. So thank you for, and something like subpoena power, you know, that is a powerful tool that we give people, and we do need to watch how we do it and who we give it to. And, you know, just because everyone else is doing it isn't always a good reason. Yes.
Quick comment. Thank
Yes.
you, Mr. Chairman.
You're right.
Senator Higdon, that's a valid question, and I remember having staff, asking staff to figure out how many boards had subpoena power, and it was a surprisingly large amount that have it. So I share your concern, and I don't believe anybody's using it unnecessarily currently, and I'm sure as long as that continues, then we'll be okay. But
and this is great, but that's what we said. They said when they gave the governor the power to do everything he's doing.
Sure, absolutely. I agree. Thank you, Mr. Chairman.
Anything else we want to talk about? Without objection, we stand adjourned.